Well, today or tonight, whenever you're watching this, we have a very special show for you today. I can guarantee that. Before we jump into the show, before we jump into perhaps what we can call a debate, lawyer to lawyer on the Karen Reed case, I just want to take care of some other business first, and that is number one. If this is your first time joining the channel, please do me a favor, subscribe. If you have any inkling to donate to the channel, help the channel out, my Venmo and PayPal is in the description. Obviously, nothing is expected, but everything's appreciated. It helps the channel grow. And of course, subscribing is free. Liking is free. So all that is very much appreciated. I want to give a special shout out to the Trial channel, who I've been using as a tremendous resource. If you want to watch trials, she goes and she cuts out all the extra stuff and makes it very easy. I think she also changes some of the audio to make it clear. So that's a great channel to check out, the Trial channel. Go check them out. They've got a lot of good stuff there. Also, I want to let everybody know before we jump into Karen Reed, and there was some news today in Karen Reed, which maybe we'll get to with our special guest. The Corey Richens case is starting next week on Monday with opening statements. The jury has been chosen already. So we are going to be all over that case. We'll see if we actually live stream it or not. Maybe we'll just stick with the recaps. But that is going to be Corey Richens. That's going to be next week. So what you're all here for today is the discussion that I am going to have with an attorney, and not just any attorney. This is an attorney who has made probably hundreds of appearances on Court TV, obviously one of their go-to attorneys for legal analysis on the Karen Reed case, along with a number of other cases that he's analyzed. You can find them, by the way, on this channel, Big Case Mike. On his YouTube channel, you can find all of the clips from Court TV that and all the analysis that he's done. Now, who is Mike Jafar? And I hope I'm saying his name correctly. Michael Jafar. And I got this straight from his website, and he'll correct me if I'm wrong when I bring him on. Michael Jafar, also known as Big Case Mike, is a highly experienced and confident personal injury attorney who has been fighting for his clients since 2006. With an impressive record of success, Michael has earned a reputation as a force to be reckoned with in the legal community. From the beginning of his legal career, Michael has demonstrated a natural talent for the law. He won his first trial with zero preparation, a remarkable feat that speaks to his unparalleled confidence and expertise in the courtroom. Since then, he has continued to achieve remarkable results for his clients, including settling an injury case for $2 million, a result that far exceeded the initial settlement offer of only $25,000. However, Michael's most notable achievement to date was being instrumental in achieving a $700,000 settlement against McDonald's Corporation. His achievement was written about in 330 news publications around the world. This achievement showcased Michael's fearless and tenacious litigator spirit and his unwavering dedication to seeking justice for his clients. In addition to his legal skills, Michael is also an accomplished entrepreneur. Having founded 4 law firms over the course of his career, he has never worked for another attorney, a testament to his independence and his unwavering dedication to his clients. You can reach him at 1-800-BIG-MIKE. So without any further ado, let's bring Mike up. Mike, thanks so much for joining the show today.
Thank you. I'm a little bit embarrassed about that. I got to tell my web guy to tone it down on that biography. That's a little embarrassing.
Well, I mean, that speaks a lot about your achievements, and that's pretty good. An entrepreneur.
Yeah, somebody who has much better writing skills than me wrote that. I gotta ask David how. Yeah, I'm sorry to you and your viewers about that biography. A little bit arrogant, a little bit narcissistic. I gotta tone it down.
Well, we're talking about one of your people that you like to call narcissistics. We're gonna get to that soon. But first, tell me about this case that you tried with zero preparation. I'm very interested about that.
My first trial ever, I was a public defender. The person there was three public defenders in my that were voted in by by the city council. He called me. I was flat broke. I was living with my parents. I was in my dad's basement, and I was wearing shorts. I had nothing to do. I was a lawyer. He told me, "Hey, I need you to come try this case for me. Is that okay?" I said, "Sure, you got it. When does the trial start?" He said, "It started 5 minutes ago." What do you mean? He said, I have a conflict of interest because the complaining victim is my existing client. I did not know that. My fault. I need you to save my ass and come try this case. The judge pushed the case over for an hour. He took a few pre-trials. I got my suit on. I went to court. It was a domestic violence case with a special prosecutor by the state of Michigan, Nicole Clay, because only the state of Michigan the AG tries domestic violence cases, not the local prosecutor. She had two witnesses. I'd never met my client. I knew nothing about the case. I came to court. It was Judge Wygonic. And, I tried the case. It was a day and a half trial. I got an acquittal. We won the case. It was my first ever trial. Had I not been thrown into it, I probably would have overthought my first trial. I probably would have prepared for 6 months. I had no preparation, not because I'm some intelligent lawyer or anything like that. I was forced to try the case with no preparation as a favor to a buddy. I thought, what's the worst I can't say no. I was completely broke. I think I made like $200 a public defender fee to try the whole case. I think it was like $180 is what I got paid to try that case. It's on the docket. It's my first trial. I got lucky. I got really lucky, and I had no preparation. I won the case.
So hold on a second. So he calls you. You're in your shorts.
Mm-hmm.
He already gave an opening statement. He didn't give an opening statement.
No. The case was called, and then the witnesses came into the back room, and then he saw the witness. It was an older lady walking with a cane, and it was his existing client. And I don't want to say the name of the attorney because he's a sitting judge right now.
Okay, yeah, no problem there. I'm just wondering.
This was 19 years ago.
Yes, I'm just wondering how you got up there and gave an opening statement without any preparation, without knowing the file. I mean, like what'd you do?
In my 20s, I was a kid. I talked to my client on the side. I took 10 minutes before the trial. Tell me your name. Her name was Ruth Loverhead. What's your name? What happened? What are they? I'm looking at what they're accusing you of. Did this happen? Did not happen. She says she has a witness. The witness is her daughter. She witnessed you abusing her, assaulting her, beating her up, trying to, put her in the hospital. She claims her injuries are from you. What's your story? And then she gave me her story. I said, the only way we're going to create reasonable doubt is I got to get these witnesses on the stand. You yourself are going to have to testify. A lot of my colleagues disagree with my etiquette on putting clients on the stand in criminal cases. I think that almost every defendant needs to take the stand. That's just my own personal opinion. I'm not right on that. That's just me. I put her on the stand, and I just worked for a day and a half. I got an acquittal. But
wow, that's pretty crazy stuff.
Yeah. So had it not been for after that, my next trial, I prepared a lot, and I actually lost my next trial with tons of preparation. But yeah, that's how it went.
That's kind of how I started. I started off winning my first trial, and then I lost like the next four. So, you kind of get a little ahead of yourself when you win your first one, and then all of a sudden reality kind of sets in, and you don't win every case. But
no, hey, that's by the way, that's the hallmark of a successful trial attorney is you have to be willing to lose cases. I listened to a podcast by Brian Beckham. He's the famous lawyer out of Houston that tried he represented all the people on the Somalian pirate ship. That there was a movie with Tom Hanks, and what he says is his philosophy, and I love his philosophy, is you have to be willing to lose cases. And the lawyer he respects is a lawyer who on his website, he lists all the cases he's won and all the cases he's lost. And he also said in the podcast, he said, I love Jerry Spence. He's dead now, so I'm not saying anything negative about him. But he claims that he has never lost a case. And I call BS on this, Brian Beckham saying, I call BS on that because if you've never lost a case, that means you haven't tried enough cases. If you try enough cases, you're going to lose cases. So yeah, I respect that about you. Yeah.
Yeah, and guess what? You know what? You learn a lot more from your losses than you do from your wins, right?
Oh, yeah. Oh, yeah.
So, all right, let's jump into Karen Read. Now, first, I'm going to talk about something that you've been very open about, so I have no problem bringing it up. You've gone on record a number of times saying you hate Karen Read. So, where does that come from? Obviously, I'm assuming you've never spoken to her, had any interaction with her. Where's that feeling coming from that you just hate Karen Read?
This is only the second time I've spoken about this case publicly since the verdict. So I even told Court TV once that verdict came down, I don't want to talk about this case anymore. They asked me to talk about it one time the day after the verdict, and I appeared with Kelly Craft and Ted Rollins. I spoke about it the day after the verdict, and then I told them I'm never going to talk about it again. This is only my second time talking about it, so forgive me if some of the facts of the case are beyond me, and I definitely don't know what has happened since then. To answer your question, I think she's a contemptible, narcissistic person. I'll tell you why. You and I, as defense attorneys, we are no stranger to having narcissistic clients who blame everybody for themselves. The system, police, society, their parents, their dad. We're no stranger to that. we expect that, right? That's not why I said I hate Karen Reed and still hate Karen Reed. The reason I do it is because you have every right to defend yourself and to put up a vigorous defense. You have not only every right, you have an obligation to your fellow man to fight prosecutors. But when you throw a whole entire community into, when you spin it into a tizzy, when you ratchet up all this anxiety, and you know how to stoke the fear of people for your own self-aggrandizement, to me, it's a step too far, right? We'll debate, you and I, whether or not she did that. But hypothetically speaking, let's just say she did that, right? That's an open question. Many people will tell me I'm wrong. But for anybody who does that, whether it's Karen Reed or somebody else, anybody who the way they defend themselves is by causing a whole entire community to implode and fight one another, to me, that's a bridge too far, right? So that's why I hate her, because I firmly believe she did that. Whether or not other people agree with me or not is a different story. But I firmly believe, and that's why, to answer your question, the reason I say I hate her is because I firmly believe she did that. That's just my personal belief.
Okay, so just to be clear, so you feel that she, because of this whole conspiracy theory, right? So, and she's putting all these people, all these, whatever it is, 40, 50 people, whatever, the number is at any given time, that, and spun this whole conspiracy and riled everybody up. And, that's different than just saying it wasn't me, it was somebody else. So that's what your issue is. So you feel that the onus is more on her than it is on Turtle Boy, for example.
No, I think he's a contemptible person as well, for sure. And I think, unfortunately, he symbolizes the evolution of the criminal jurisprudence system. But he gave her power, he gave her strength, and he gave her kind of like a get out of jail free card. He didn't call her and say, here's a get out of jail free card. But he's the worst of the worst. She was actually a successful, professional person, right? She should have known better. But I also think back and I think to myself, if I was about to go to jail for 20 years, what would I do if there was a guy gaining traction online saying everybody else is to blame and there's a conspiracy? Because in Boston, it's just different. And I've said this publicly, and I know friends in Boston. Every single person I know in Massachusetts thinks she's innocent and that there's a conspiracy. And that one person I asked said, I live in Canton. I know the Alberts. I actually know them. And I know that they did this, and I know that they murdered John O'Keefe. This is an accountant, by the way, not just some conspiracy lady. So Karen Reed knew that. In my opinion, she knew that she could. It was a powder keg, and all she had to do was throw a match into it. Again, my opinion, but that's what I believe. But yes, to answer your question, I think her and Turtle Boy in the same cast for me.
Right. But I think the question is, who was more responsible for spinning the whole conspiracy theory? You seem to be saying it's Karen Reed. I think a lot of people would say, no, it's Turtle Boy getting on his channel every single night, talking about the Alberts and the McCabe's and that they're all doing this. And, Karen Reed is just there defending herself and saying that she didn't do it. So the question is, or your hatred, perhaps misplaced, that it's to Karen Reed as opposed to what it really should be, perhaps Turtle Boy.
No, I agree with you that it's more Turtle Boy. He started it and he ratcheted it up more. But I hate Karen Reed because Karen Reed brought it. She was in the room with attorneys, and she knew that she had a bullhorn, and she knew that she could really take it to the next level. And so I put my angst on Karen Reed. But to answer your question, you are correct. It starts with Turtle Boy. Without Turtle Boy, I don't believe there is a Karen Reed. There's a Karen Reed, but I don't believe there is a Karen Reed. The real Karen Reed is a person who sat with Michael Yannetti in the beginning and started coming up, David Yannetti, coming up with ways to maybe enter into a plea, maybe reduce it, maybe fight it. That's the real Karen Reed. Turtle Boy, in my opinion, gave her the ammunition, but she didn't have to take it in the way she did. So yes, I believe Turtle Boy is more responsible. But for me, my focus is on Karen Reed because she's, in my opinion, the antagonist of this whole entire thing.
Okay, so you think that she's kind of behind Turtle Boy or feeding him some information to fire up and stoke the coals of this whole conspiracy theory, and that's why you're outspoken about your hatred to her.
No, I don't think that she's behind him. I think that he created his own. He created the theory on his own, right? And what I think she did, what was pretty apparent she did, again, whether or not she killed John O'Keefe or not, what is apparent to me is she took it, she looked at it as like a life raft, she jumped on it and she pushed it. That's what I believe.
Okay. All right. So let's get to the ultimate question of the night tonight. And that is, did Hank Brennan prove beyond a reasonable doubt that Karen Reed murdered John O'Keefe? Number one, I want to ask you the second degree murder. And number two, I want to talk about the manslaughter. So which one or both, or do you think that he proved in the trial?
My answer on this is going to be controversial. I fully believe in what I'm going to tell you. I never thought that murder two as a moral point was proven in either case. Okay. But I have to put a caveat to that. I spoke to I forget the guy's name. He was also on Court TV, the very experienced criminal defense attorney in Boston. Man, I'm drawing a blank. He analyzed this case. He said that there's a unique law in Massachusetts that says if you intended to create the action that resulted in the death of a human being, murder two is a proper charge. I was on TV saying after there was a hung jury in the first trial, they should not bring murder two in the second trial. Because I said, I said, no matter what the statute in Massachusetts says, I don't think that people there are going to come to the point where they believe Karen Reed wanted to cause the death of John O'Keefe, right? So I never thought from a moral point that Karen Reed intended the death of John O'Keefe. But I fully believe that Hank Brennan proved this case beyond a reasonable doubt on the second charge and the third charge. I fully believe that. So that's what I believe. And we can get into the details as to why, but yeah. I do believe he proved it.
So then let me ask you this question. So you don't think intent is there? Did she intend great bodily harm?
Yeah, I do believe she intended great bodily harm. Yes. Well, I believe she was reckless in causing it. I don't believe
that's the difference. I mean, that's the difference.
Yeah.
So do you think that she intended to hurt him with the car, or she was just driving recklessly because she was super drunk?
I think she was completely reckless, completely they don't have a super drunk law in Massachusetts like we do in Michigan, but she was beyond drunk. And I believe that she was extremely reckless, just getting behind the wheel. Had she just ran a red light and murdered somebody, it would be the same type of intent that she had formed as if she was trying to kill that person by her being so drunk. I believe that she did that. That is in fact what happened. I don't believe her intent was to end the life of John O'Keefe, but I do believe she was reckless in her behavior. Yes.
So here's the question, because I mean, I think this is where you're going to get some blowback from the people that believe that second degree murder was proved. And that is that there is data that her car went in reverse 24 miles per hour. Mm-hmm. So usually you don't drive like that unless you intend to go backwards 24 miles per hour and hit somebody. That's not just driving recklessly, flying down a highway drunk. She put the car in reverse. She drove up, put the car in reverse, 24 miles per hour backwards, gunned it. Seconds after John O'Keefe left the car. Does that not equal intent?
No, a lot of people will say it does. And I wouldn't fight those people. That's just my personal belief that a jury in the second trial was not going to absorb the message of Hank Brennan saying that she's guilty. However, if she was found guilty of it, it wouldn't have shocked me. And according to the attorney, and I can't believe I'm blanking on his name. This is a very well-known attorney there. He said that the statute there makes it clear that murder two was the proper charge. So, I don't think there would be if there is pushback, what I tell those people is, hey, I'm with you. If she was found guilty of it, I would not at all be shocked. I just feel like your easy case was the second case, and that's all you ever had the ability to do. Listen, one more thing. What I said before the second trial started, I said, Hank Brennan knows that it's not enough for him to prove his case beyond a reasonable doubt. He's got to prove his case beyond a delusional doubt. And I just don't think you're going to prove your case beyond a delusional doubt. And unfortunately, based on the way the jurors interviewed after the case, unfortunately, that ended up being correct.
Yeah, but I'm asking you, if you were a sitting juror on this case, I mean, you're an attorney, you watched the case like I did. And in your mind, I want to know in your mind, did he prove that by her throwing the car into 24 miles per hour, she intended to kill him, and therefore she's guilty of second-degree murder in your mind?
By the letter of the statute of Massachusetts, I would have found her guilty. Yes.
Okay.
And I think
so
that's
then,
why she had a hung jury in the first case. But yes.
okay, fine. So good. So then, I mean, I'm just making it clear that
Yeah.
your opinion is that he proved this case beyond a reasonable doubt, even for the second degree murder, because by her
Yes.
putting the car into 24 miles per hour backwards and then
Yes.
gunning it, obviously she's telling me, because I'll tell you why. Because I when I hear this argument sometimes that, you know, they should have found her guilty on the manslaughter and not the intent. I don't know what people do with the 24 mile per hour backward maneuver, because if you look at the way that she was driving up until that point, she was stopping at stop signs, she was going the speed limit. She, as super drunk as she was at the time, she was driving pretty safely, and there were no other triggering events that we know of that night after she left, for example, 34 Fairview, that they could point to either. So it was very intentional in my mind, if you're going to be in that camp, that she put the car in reverse and she intended 100% to go backwards. And if you're going to find that she murdered him, well, then the intent to me is there. I don't see how you get to just manslaughter and not to second degree murder just by the backwards maneuver. That's where.
No. Yeah. If you're asking me if I was on the jury, would I have reached the conclusion you just reached? The answer is absolutely yes. But again,
Okay.
I would like to think myself as being a little bit more rational than people living in the powder keg, right? I'm not even blaming them. They live in the powder keg. They grow up in that powder keg, and their distrust of their local government is on a level I've just never witnessed. So
Right. Okay.
to me,
So yes, you're talking about how the jury would maybe, you know, be more comfortable finding her manslaughter as opposed to second degree. But as your legal opinion is that she was guilty and it was proven of second degree murder. So here's a question that I'm wondering myself when I was watching this, and you know, I try to watch it as objectively as I can from both sides. And here's one of the issues that I have. So from the evidence, she pulled up to the flagpole first. That's where her car stopped. That was according to the data. Basically, you know, she was moving up closely and then eventually stopped by the flagpole, as you know, the flagpole.
Yeah.
Then, according to the data, she went forward 34 feet, and then she went backwards from 34 feet forward. She went backwards 87 feet. So my question to you would be, at what point did she hit John O'Keefe?
So my recollection of the evidence that was presented in the second trial, right, by Hank Brennan, and some of the facts are a little bit hazy for me now because again I've tuned this case out.
Well, I'll try to correct you if you need.
Yeah, and feel free to do that. From my recollection, especially the way he brought it home in his closing statement, you can track every single foot forward and backward in that car, right down to the place within like a 3 feet variance of where he was found dead, a little bit into the grass, right? So I'm forgetting right now the actual exact number of feet forward and backward, but he tracked it, and he tracked it in almost incontrovertible data. And the other thing is that John O'Keefe was dead within 20 seconds after he left her car. And I forget the number of steps, the max number of steps he could have taken. I'm forgetting that amount, but he said even if he tried to get to the front door, he would have only made it to the front door and been dead at the front door. So to answer your question, I remember the Hank Brennan tracking the exact footsteps, the exact number of feet forward in the car and backward down to within a 3 foot variance of where he was found dead.
Right. It was 34 feet back. I'm telling you, it was 34 feet forward, and then she went backwards 87 feet. Now, remember, it's from the flagpole, 34 feet forward, 87 backwards. And by the way, her foot was still pressed on the accelerated 74%. It means that she was still going. So my question always is, at what point was John O'Keefe hit? And I think the most reasonable one, and you can correct me if I'm wrong, I think the most reasonable answer would be by the flagpole, because that's where his body was found after.
Yeah.
So
okay. So that would be reasonable.
Right. So here's my problem with that, is that if she went forward 34 feet, that means backwards 34 feet is where she originally started from, and that's the flagpole. That's where there would have been contact between her vehicle and John O'Keefe's arm,
body,
right?
Yeah.
But then that means that after she hit him, she continued backwards for another 54 feet and even more because she was still pressing the accelerator.
Yeah.
So That's hard for me to comprehend. After she hit him, why would she continue going backwards another 54 feet and even more?
Yeah, I could tell you. I could tell you why that would happen. It was night. She was drunk. If she was driving backwards that way, she would have been irate. I think what she wanted to do is give him a piece of her mind. Hey, you dirtbag this, you dirtbag that. So there's multiple reasons where because it's not like if she hit him, it's like hitting a wall. She hitting his arm. So it's not like she would have like hit him and then hit the brake. She would have kept going back and back and back. If you're that drunk and you're that irate, and when you look at the voicemail she left him on her way home, and the way she was talking was she completely lost control. So a person would do that. To answer your question, a person who's already lost control of themselves and of their senses and are doing something already that is out of character for them, that would explain why she kept going back another 50 feet. I mean, another 50 feet is not that much of, it's not that big of a space when you're going that fast in the vehicle.
Okay, so again, so like just to nail down your position, so your reasonable conclusion is that he was hit at the flagpole, and then she continued back 54 feet, and even more so. So my next question would be, was Brian Higgins' Jeep there or not?
I forget if Brian Higgins' Jeep was in the driveway or on the street. I know another vehicle was there seeing them. That's part of the details that right now, I've buried, but I forget the specifics.
So that was actually one of the disputes in the testimony. There was I believe it was Jennifer McCabe who said that Brian Higgins parked his Jeep on the street, which would be behind where Karen Reed was backing into. So I think a lot of people is wondering is that if she really actually did this maneuver, she would have collided with Brian Higgins' Jeep, which would mean then that you'd have to say, well, we're going to have to discount Jennifer McCabe's testimony and believe the other people. And then the question is, well, if we discount that part of Jennifer McCabe's testimony, do we discount other parts of Jennifer McCabe's testimony?
No, let me answer your question with a question. Did Jennifer McCabe, if I recall correctly, did she say for sure Brian Higgins' Jeep was on the street? That I'm forgetting.
I don't think she used that word, but that's what her testimony was, that his Jeep was in. And I believe Jennifer McCabe was definitely one of the witnesses. I believe was Jennifer McCabe.
Yeah, let's assume that Brian Higgins' Jeep was actually on the street. She didn't necessarily have to hit Brian Higgins. She had a brand new car. She had sensors. She had a rear view camera. She would have turned a little bit and avoided it. So there's many ways where she wouldn't have hit, Brian, assuming Brian Higgins' Jeep was on the street, there's many ways where she would have avoided hitting Brian Higgins' his vehicle. Because for me, I just look at the totality of the circumstantial evidence. The circumstantial evidence cannot be seen in any light unless a person realizes her broken taillight, which I know you were going to want to get to later. Her broken taillight, the shards of it were found around his body and some of it in his clothing. I just don't see, because the only way to make it sense, to have it make sense, is to say there was a conspiracy to break her taillight somewhere else and bring it back and bury it in his clothing. For me, that's where I was lost. And because all the discussion of what happened with the feet backwards and the feet forward, it has to be put in context with the broken shards of taillight. Without that, the evidence is lacking.
Okay, so here's another question then. Again, assuming that she backed up her car, because that's what the case is all about, that she backed up the car, hit him with his arm, and then the question is, now he was found located 7 to 10 feet off of the curb. So he didn't just drop there.
Yeah.
Remember, he suffered a blunt trauma force in the back of his head. So how did he get 7 to 10 feet off of the curb? What's your?
I can tell you what was said in the trial and what I believe. So he had the indications of a pedestrian strike, right? You and I do personal injury cases. We're very familiar with pedestrian strikes. One shoe was off his feet, right? That's like almost every. Yeah, on the curb. Every pedestrian strike has somebody missing a foot, right? He did not die right away. Pedestrian strikes rarely kill somebody unless they're head on, right? From the front or from the back. He would have been sideswiped. He would have died, he was dead 20 seconds later. So in that 20 seconds, he could have gotten off the curb. He was injured. He was traumatized. It's completely understandable that a person in that type of state would have veered off the curve intentionally. Right. So to me, it was almost like a nothing burger, in terms of why was he not found on the street? Well, because he wasn't dead on the street. He was dead, 20 seconds later.
Did he stumble there? How did he get there? Was he spun around? Did he fly in the air?
That's when proponents of both sides just completely guess. I would be guessing. I don't think anybody on either side was able to say conclusively, did he stumble there? If she killed him, if she hit him, then there's only one way he would have gotten there, which is not he would have been thrown there. He would have, crawled there and gotten off the street. Just I put myself in the position of anybody who's struck with a vehicle, right? What are you going to do? You're going to try to get out of danger. And if your body's not functioning properly and you're about to be dead, you're going to crawl there. You're going to limp there. Something is going to happen to get you there.
But he fell backwards and he smashed his head. And according to some of the testimony, he was knocked immediately unconscious. He wouldn't be able to crawl there.
Yeah.
So how does he get there?
No, he could have what his blunt force trauma on the back of his head. Ironically, during that second trial, I had a client, a 52-year-old guy, slip and fell backwards on the stairs. Right. He bled out. He died instantly. Right. His wound was so vicious that he had blood all over the house. Right. And then there are people who slip backwards and hit their head and have a similar blunt force trauma and they survive and they walk away. So, and then there's a spectrum between between being dead right away, dead later, not dead at all, just injured. So, like it's that famous case, the Michael, Stevenson case out of North Carolina, the stairway case, right? Where she, the evidence was that she slipped backwards, she hit her head, she woke up, she got up, slipped back, hit her head again. So it's not like a linear thing where he couldn't have crawled if he had the blunt force trauma, right? And again, for me, what gets me back to the center is the evidence of the taillight being found in his clothing, and it would have been impossible. There was not enough intelligent people on the Alpert side to really choreograph it to look the way it did.
Right. So I'm just coming back, and we're going to get to the taillight in a minute, but just coming back to him falling. So I'm just trying to understand the theory. So just to be clear, your theory was that he fell backwards and suffered that blunt force trauma to the back of his head, which killed him almost instantly. And during that few seconds that he was dying, he crawled over to the flagpole.
No. He didn't die instantly. He was dead within 20 seconds. So he had a 20-second variance between getting struck and dying.
That's what I'm saying. Right. So because according to one of the experts here, La Posada, is that he was knocked unconscious immediately with that blunt force trauma, and he was not able to make any sort of purposeful movement at all. So you have to discount that testimony in order to get there.
He could have been thrown. He could have been thrown off the curb and crawled out of harm's way within 2 seconds. He could have been thrown that way and not crawled. He could have hit his head and then had another 20 seconds to try to survive. Either way, he got there. And for me, looking at the case and analyzing the case, there was no rational explanation in any way, shape, or form other than Karen Reed hitting him with the car. There was just no other rational explanation. And Hank Brennan showed it, like piece by piece by piece, second by second by second.
So let me just maybe help you out with that theory. So then is it, maybe you're saying that he was hit by the arm, was spun around and was still spinning around and then eventually landed near the flagpole, and that's where he smashed his head and that's where he's stuck. Because because I feel that once, again, according to the testimony that I saw, once that blunt force trauma was to his head, he could not make any purposeful movement, which would include crawling or any other way to get to that flagpole. So the only thing that would make sense to me is that spun him around, he stumbled around, and then landed right near the flagpole where he suffered that blunt force trauma. Is that what you would say is what happened? Or because if he died near the curb and that's where he suffered the blunt force trauma, I don't see how he gets to the flagpole.
Yeah, if he died suddenly with the blunt force trauma, and there was one expert who said, he couldn't have made any purposeful movement, but that was an expert saying that, right? Nobody really knows. Like there's, you and I as criminal defense attorneys, as experts, not us as testifying as experts. No expert has all the explanations of what happens in the body mechanics after a person suffers blunt force trauma. Nobody has the answer. If we are to take as gospel what any expert says, there's experts on one side that prove one case. There's experts on another side that prove another case. But at the end of the day, there are some things that are objective, right? Like a video, which we don't have here. But there are some things that are very subjective, Martin. And one of them is any expert on any side saying exactly what happens to a body after a person suffers any kind of injury, right? There was a case where an expert testified what would happen to the human to the coagulation in your blood if you are hit with a spear with the carotid artery, right? You will die, you'll bleed out instantly, die instantly. Some people say you'll die within 2 seconds. Some people say you'll die within 70 seconds, right? It's not really known, and every body is different and every person is different. But if we are to take as gospel, right? As gospel that he hit the curb, he was instantly dead, then yeah, then the question then becomes, well, how was he found off the curve? The only explanation is somebody took him off the curve. Then people on the other side of the Karen Reed case will say, well, who would have taken him off the curve? It would have had to have been a conspiracy, but then again, somebody would have seen Karen Reed kill him, and then they would have helped Karen Reed cover it up. Or you say he went into the Albert household, he died on the stairs, and then they carried him out, right? The further we get from the curb, and I guess here's what I said, the further we get from the curb, the more absurd the theory becomes. And I called it the Bigfoot theory, right? Because I've said it's more likely that Bigfoot himself popped out of the forest and killed John O'Keefe than to believe Karen Reed's actual defense theory, which is that he went in the house, which is why in the second trial, Alan Jackson, who I think is a fantastic defense attorney, I don't believe they even brought a third-party culprit thing in the second trial. You can correct me if I'm wrong about that.
No, they didn't.
They didn't bring it because they realized how absurd it was. Not because they thought they'd proven their case and they didn't have to do it, because of course they would have brought it if they thought it was beyond absurd. But you're asking the question of, if he hit the curb and he had sudden death, how did he get off the curb? Nobody knows whether or not that expert is correct that he died suddenly. He could have said that, but there have been thousands of experts who've testified in thousands of criminal defense cases where they were so certain that a certain biometric thing happened. And then when DNA was uncovered, it realized, oh, this didn't happen. So, I mean, I guess that's my long-winded answer of that question.
Yeah, no. So because really what it comes out to is, if you have this expert that says, and, let's call her Dr. La Posada, and she says that as soon as he got that trauma to the back of his head, he was dead, not making any sort of purposeful movements, would never be able to move. The question then people have is that, does that create reasonable doubt in and of itself? And what it seems to me you're saying is that, no, it doesn't.
No, it does not create reasonable doubt in and of itself. And I have a deep answer on that. When they did the study, I think when Vinny Politan did a survey on his podcast, on his podcast or website, 87% of people in Massachusetts believe Karen Reed was factually innocent. Not that the case wasn't proven beyond a reasonable doubt, that she's factually innocent. And then a close percentage to that believe that the Alberts murdered John O'Keefe, right? So to me, I do not believe it creates reasonable doubt, because if you look at the case rationally, right, as a population, and I don't mean that in any kind of condescending ways, it's just my own opinion, right? My own opinion. If you
say it how you want, Mike.
Yeah, if you look at the case rationally, right?
I can handle it.
Yeah, and not I'm not saying that you're not looking at it rationally. You're asking questions. I'm saying I'm so accustomed to talking about this case publicly back during the trial. You have to look at the totality of everything that happened, because Dr. La Posada said, he was killed instantly, but then he's found really close to where she thinks he was killed instantly. But I recall Hank Brennan exposing on redirect that he could have crawled, he could have moved. Forgive me if I'm wrong on this, but that's my recollection of how he brought it all together. But Dr. La Posada was an expert, but an expert who wasn't there. And at the end of the day, the human body makes gyrations and movements after it's dead or before it's dead or right before it's dead that no scientific explanation clarifies what happens. People's heartbeat stop and then they come back to life for 10 seconds and then die again. So all kinds of things can happen in a biomechanical situation.
Okay, fine. So I just to be very clear there. So Dr. La Posada's testimony by itself does not, in your mind, create reasonable doubt, obviously.
Yeah, of course.
Okay.
Yeah, I don't think it creates reasonable doubt. That's all.
Okay, let me pull up a clip. Actually, I found this clip of you, and I want to ask you.
Oh God.
I want to ask you if anything's changed since you made this clip. So take a listen.
I tend to agree with the defense attorney when he showed the pictures of the lacerations and what his arm looked like. Yeah, that's not a cocktail glass. That's definitely a dog attack, and that swayed me dramatically.
I was going to bring this up. I'm kicking myself for not bringing this up. So here's why I'm so confident that my analysis of this case is right. And I've said this, and I said this. I told you I've spoken about this case twice publicly. Once today with you, once a couple of weeks ago. I brought this up. I said I was on Team Karen Reed. There was a motion hearing. I said in March of I think 2024, where when I first found out about the case, right, there was a motion to compel production of evidence. And what I said, and I so like, and many people have agreed with me on this. The prosecution and the state screwed themselves in this case. They made humongous mistakes that us as defense attorneys, we know what they are. They refused to turn over the evidence to the defense for independent testing of the blood to see if there was canine marks, DNA, right? And I said, I know why they did it. They did it because it was not a high profile case, and they did this dumb thing that prosecutors do all the time that bothers me. Even defense attorneys in personal injury cases do it all the time. Let's make them work. Let's not turn it over. Let's make them fight to get it. And I thought to myself, how dumb can you be to not turn over something that you know for a fact you have to turn over and let them independently test it? And they didn't do it, which gave them the ability to file a motion to compel. And they went into that hearing, and Alan Jackson put up pictures of John O'Keefe's arm and said, look at this. This is not a cocktail glass. We believe that he was mauled by a dog in the house. And when I saw that, and I was very public about it, I said, that doesn't look like like shards of glass. The state does have something to hide. Why wouldn't they turn this over? They need to turn this over. They didn't do it. And so they screwed themselves by doing that, because they gave care. That was when the Karen Reed case first took public limelight. That was when it first became, that's when she was able to ratchet up the public and say, look at what they're doing to me. They're covering it up. But later on, what didn't get public attention, what the Turtle Boy didn't change his mind after this came out, Karen Reed didn't say this is wrong, is when the stuff was turned over. There was two pieces of evidence turned over in that motion to compel. It was the ability to do independent DNA testing and the letters between the state and the federal government. All that stuff was turned over, right? What wasn't publicized is it all came out negative. There was no canine DNA. And then what we also didn't know from those pictures is we did not see the inside of his arm, because Hank Brennan proved it to me. Look, I looked at this case like a juror, not a lawyer. He came on, he said, hey, listen, if it was a canine, if it was a mauling, why was there only scratches on the outside of his arm, not the inside of his arm? Was it a canine that didn't have incisors? Was it a canine with just one top of the jaw, not a bottom of the jaw, and just gnawing at John O'Keefe? That doesn't make any sense. These are scavenger scratches. And it was tested for canine DNA, and it was negative. So he proved his case. This was before, this clip that you just showed was a year before the first trial, right? And a year before the first trial, when I saw the state covering up and not giving the evidence to the defense for them to prepare for their defense, I was on Team Karen Reed, because at the time, none of us knew anything. We just knew the sensationalism. And the one last thing I want to say is, I said, there's no way a guy like Alan Jackson would believe his client if she told him that there's a conspiracy, unless she convinced him of that. She went into her attorney's office, said, there's a conspiracy. I need you to help me. I would have bought that. But they already tested all that stuff ever since that was like 2.5, 3 years ago. They tested all that stuff, and it came out negative. And every part of her conspiracy theory was so thoroughly debunked that it culminates at the end of the second case, where her defense did not even put up a third party culprit. So I'm glad you played that. I'm kicking myself for not bringing it up, because I was going to bring it up earlier. I'm like, let me wait. But I'm glad you brought that up. But yes, I was on. You have to always look at people who see both sides of a case, and they're with you on some parts, and then you lose them later on. There are some people on the anti-Karen Reed, which I tell them, like, dude, you got to chill. Like they've always been against Karen Reed. They've always said, this is BS. This is it. And then there are people who, no matter what evidence you put in front of them on the Karen Reed case, they never change their mind. They bounce from one theory to the other theory to the other theory. But Yeah, that's what was behind that interview.
So I'll tell you something, because this picture of the arm, which is what you're referring to, I don't have to play it. I don't have to put it up because everybody knows this picture already of the arm. Anybody who's familiar with the Karen Reed case. So that picture, like you said, that's definitely dog bites. You know, that's basically what you said in that interview, right?
I didn't hear you. What? Definitely what? I didn't hear you.
That's definitely dog bites, right? I mean, that's
Yeah.
basically what you said that day, whatever it is.
That day,
So,
yeah.
Right. So, and I think when you show this picture, and this is my experience, and I just random people, random lawyers that I meet in the courtroom or meet around, and I say, hey, what's that from? Nobody's going to say it's from a car. They all say it's some sort of animal attack.
I agree.
And so my question to you is then, what caused you to change your opinion about the that not being from a dog? If it was so
Excellent
obvious and
question.
clear from the
Excellent
beginning,
question.
what changed? What caused you to change your opinion?
Excellent question. I'm gonna and that's the first time somebody asked me that question. I have to tell you, I really appreciate this conversation, because if people had these types of high-minded debates on the Karen Reed case, it would have been a completely different case. Because you and I, as attorneys, this is what we do: is we argue cases, we argue facts. And as I always said, there are three camps in the Karen Reed case. There's a camp where they believe that she did it. There's a camp where they believe they don't know, but the case wasn't proven. And then there's a camp where they believe that Bigfoot killed John O'Keefe, right? And people in camp one and camp two, all day, that's our profession, right? I've had many clients, who, I could not agree with the other side. Here's the answer to your question. Here's what has changed. Me as a witness, I sat down and I realized, what the hell do I know? Nothing. Let me see because I'm not a canine expert, right? I'm an attorney. So how would I have attacked this case or any case? I would have looked at things that I know are known issues, known potential, what we call legal gaps, right? And I would have created a logic tree. And I create a logic tree in every case I'm getting ready for trial. And I look at the logic tree and I ask myself, what are the factual gaps? What are the evidentiary gaps? What are the things that I need to bridge in depositions? Who do I need to depose, right? And if I was on this case, I would have said, I need to know what these marks are from. Well, that's what Hank Brennan did. He brought in experts who actually know this stuff. The defense didn't. They brought in this lady, a really nice lady, a hapless lady, a female version of Santa Claus. They brought her in, and she's not an expert. She was an ER doctor who has looked at dog bites. They brought in actual experts, and the actual expert taught me. They didn't talk to me. I watched it on trial. They taught me because I sat down and I listened, and I said, you know what, let me see what these are. And that person explained, this is a scavenger. It's not a dog. I never believed, I still don't believe, nor did Hank Brennan believe that those were injuries from a car accident. Maybe that one expert they brought in, the accident reconstructionist, I forget whether or not he tried to say this from a car accident, but they brought in experts who said, this is a scavenger. It's not a dog, because a dog would clamp your arm from both sides, and there were no injuries on the inside of his arm. When I heard that, I said, you know what? That explains that mystery for me. I can put it aside and look at the other thing. Because if he would have been dead for 5 hours outside, of course a scavenger could have gotten to his arm. So I after the end of the second trial, I no longer believe it was a dog. I definitely don't believe it's a dog in the Alpert home, which was the whole theory. Remember, Alan Jackson, in that analysis that I did, he had a hearing where he said, we believe he was mauled inside the Alpert home, and here's our evidence. That ended up being thoroughly debunked.
Right. So here's the problem, Mike. From what I remember, there was no expert that the defense brought to show that they're not dog bites. I know that they were going to perhaps call a guy Crosby. But he never ended up testifying. So all we had in the case in terms of expert testimony about whether that was from a dog or not was Dr. Marie Russell. And I would argue that she is an expert. She's got 30 years experience treating in the ER. She has 30 years experience as a forensic examiner. She dealt with a lot of cases of dog bites and also people that were killed as a result of a dog. And she, using her methodology, came to the conclusion that they were from a dog. And the only evidence that I heard contrary to that was not from any expert that the prosecution called, but what I keep hearing is that, well, there's no DNA. There's no dog DNA. And from what I remember is that the only areas that were swabbed was the T-shirt. But the actual wounds were not swabbed for DNA, for dog DNA. So we can have a discussion about the clothing, which we will in a minute. But in terms of experts, I'm going to have to take an issue with that because I don't think there was a single expert that the prosecution brought up that said that those were not from a dog. The only closest that I'll give you is Welcher, And Welcher didn't say specifically that it's from the car. He didn't really run many force tests at all to see how it would shatter and how it would cause those things. He just said, well, it lines up. So if you put your arm there, it lines up. Well, I guess that's what it's from.
I recall that. Yeah, I recall that.
Yeah, I mean, that's the closest that you're going to get to me. And I mean, Dr. Marie Russell to me was very credible. She had a methodology. Do you disagree that she did not have a methodology?
I do not believe that Dr. Marie Russell had a methodology or that she was qualified to testify to that, because, and so many things are blurred in during that second case, because I analyze this case every day, and there were so many experts that were on TV that were talking about the case that I spoke to. Every single expert in unison said, if there was a dog bite, if this was a dog or any kind of a mauling, there would no question be the same or similar marks on the opposite flip side of the arm, and there was nothing, right? And so again, the expert says, unless this is a dog that only has one side of the jaw, top side of the jaw, not the bottom side of the jaw. And that's, to me, Dr. Marie Russell was totally debunked with that theory. And nobody can explain to me how a dog could injure a person at the top of their arm, not the other side of the arm. Whether or not they introduced that expert in the second trial, again, things are blurred for me, because
there was no expert like that. I mean, I think I think what you're referring to about this mauling, it wasn't the papers, but in terms of actually presenting this testimony, there was no expert that came on and said that there would be dog bites on the bottom of the arm too. I know that this argument was made, but there was no expert that testified to that. The closest that you'll have is Welcher, who lined up his arm with the car and said, yeah, it kind of matches, so maybe that's what it's from. So
I'll tell you something funny. So during that second trial, and this is why I have PTSD, and as I said, I'm not going to discuss it anymore. I was on a panel 5 days a week with actual experts, like dog experts, when this was an issue, and they pit us against one another, 2 versus 2, lawyer expert, and we would sit there and debate live, by the way, not recorded. And for later, like live shows, and every expert that looked at this case said, these are not dog bites, and here's why. And the fact that the DNA was swabbed negative for K9, and the fact that the defense never brought this as a theory in the second case, to me, I put all of it together and said, this was not a dog. This was not a mauling.
Right. But, okay. So I mean, perhaps you're talking about experts that appeared on court TV. But I'm talking about what actually was presented in trial. Now, I will say also, I'm going to take issue with this, is that even Judge Cannoni agreed that Marie Russell had a methodology. That's why we had a 2-day Daubert hearing. And she did say it was a close call, but she agreed that it's a methodology, and Marie Russell said it's pattern recognition analysis, and Brennan tried to look at each one individually, and that's not how patterns work. So, I mean, again, to me, sitting in my seat, I see an expert saying these are dog marks. The prosecution doesn't put out a expert, and you and I both know about causation. When you're talking about causation, you need a medical doctor to be able to opine about that. And maybe we'll get to Crosby and that problem later. But
that's fair.
In terms of medical doctor opining on causation or lack of causation, you need a medical doctor. And there was no medical doctor the prosecution presented that would say that they're not dog bites, which to me, again, shows that there's reasonable doubt here. Maybe there was some sort of a dog, and I can't tell you where, what, when, and how, but I'm just looking at the body, looking at the evidence, and saying, hey,
can I give you credit for something? Can I give you credit for something? Let's turn off the heat. But my wife turned on the. Are we able to pause? I'll be right back.
Go ahead.
Give me 30 seconds. Give me 30 seconds.
You got it.
All right.
No problem.
Okay. Let me address what you're saying. So I got to give you credit for something, which is you've exposed weaknesses in Hank Brennan's case. It was not a perfect, flawless case. I said at the beginning of the trial that every big major media case, every side is going to make 3 small mistakes and 1 big mistake. And one of the small mistakes that Hank Brennan did was that.
We'll talk about the big mistakes.
I make tons of mistakes. I only make mistakes. I get lucky. I promise you. But yeah, it's a mistake to do it. He would have convinced himself that he needed to have a more short, concise, case in chief, which, as is evidenced by the fact, I think he brought in half the witnesses from the prior trial, half or close to half. Based on the interviews of the jurors after that, I don't recall any of them saying that they thought it was a dog. Again, we were all convinced it was a dog. all of us, including me, before a year before the first trial started. And me after that, after listening to experts, if not testify in court, like talk about the case publicly, you know, I forget the type of expert that is right in line with it. It's not because Dr. Marie Russell is a doctor, is an ER doctor. I agree with you that she was brought in by Judge Beverly Canoni, but there's a level above that. I forget the type of expert on dog. I forget the
Like a
name.
dog behavior expert like Crosby?
Not a dog behavior expert. No.
Because Crosby, he could have called Crosby. I mean, he could have done it.
Yeah.
You know, even though you and I both know
It's
that
a
only
mistake.
medical. Well, he didn't,
Yeah.
but he
Yeah.
agreed with you, obviously. But you know, you and I both know that medical doctors are the only ones that can testify about causation. I mean, that's how it works in Michigan.
Yeah.
So I think if he was so confident in that it was not from a dog, I think he should have had a doctor say that.
No, but I don't think the issue of the dog was causation. I think the issue is whether or not that's a dog at all. I don't think it would have been. The issue was, did the dog bite kill him? I think the question is, was it a dog at all? Because it was a specific dog in that case. It was the one in the Albert home. I forget her name. So that's
Chloe.
why I don't. Yeah, Chloe. So I don't think it was a causation issue. I think it was, hey, was he in the house? And if so, was he mauled by Chloe along the way to being murdered by the Alberts with blunt force trauma in his head? So the whole thing, hindsight 2020 for Hank Brennan, but that would have been one of his mistakes.
Okay. Yeah. I mean, I think, and I got to tell you that for me, that's what is strengthening the reasonable doubt for me, which is why, I have a lot of me says that, Dr. Marie Russell went largely uncontradicted, and she was the one that said that they're not from a car, they're from a dog. Well, if it's not from a car, then the car didn't hit him. If the car didn't hit him, then Karen Reed didn't murder him.
Well, let me ask you, hold on. Now that's a huge leap that I want to debate with you.
Sure.
Assuming it's a dog, and to me, it's clear not a dog, because again, still nobody has told me how a dog could get one side of your arm, not the other side of your arm. But let's just assume, for sake of argument, it is a dog. How would that cause you to take the leap that means Karen Reed didn't hit him? I mean, her car did reverse. He was found dead very close to where she reversed. Her broken taillight shards were found in his clothing, and he had blunt force trauma on the back of his head, which is indicative of him falling back and hitting his head. And he clearly was not murdered by a dog. But even if those are from a dog, to me, I could never make that leap. It's a reasonable debate point by you. I just
well, here's the problem. If the car didn't cause those injuries to his arm, that means that the car didn't hit him, right? I mean, that's the entire prosecution's case. Well, the entire prosecution's case is that he was hit by that car. And where's the evidence?
But the prosecution's case was not that those injuries were caused by the hitting of the car. I mean, he was out there in the snow for 5 hours. It's very reasonable for a scavenger to have scavenged and scratched his arm.
So are you suggesting that? But your suggestion is that he was there and the car did not cause those injuries to his arm, but they came later. The scavengers came later while he was
It could have come later, or from the car, but I think it could have come later. Yeah.
So two problems with that. Number one is that the testimony was that these injuries were pre-mortem, before he died. So all the experts agreed with that these injuries to his arm came before he died. So it's not that he was lying out there dead already because of the blunt force trauma, and then some scavenger came. That the experts agreed upon. Yeah. So somehow he had to have been alive, had those injuries inflicted on him, and if they're not from a car, then what's her culpability in it?
One of their expert, if I recall correctly, the one in the second trial, the guy with the demonstration. Remind me, and this is where I'm going to ask.
Yeah, Wolf.
Yeah, Wolf. I'm going to ask you for your help and assistance on it, because it's been a while.
Sure.
If I recall correctly, he showed that the car backing up based on John O'Keefe's height and his position, that his arm was hit right then and there. And if I recall correctly, he had some sort of a blue residue or something like that.
Okay, that's Welcher. That's Welcher.
Something like that. And he showed that his arm was impacted in the same way that John O'Keefe's arm was impacted, if I recall correctly. Is that right?
What he showed was, this is Welcher, and this is Hank Brennan's witness, his biomechanical engineer. And he showed that, when you line up your arm with the taillight and you put blue paint on it, so then, it'll transfer to around the same area where the injuries were found.
And he was holding a glass during the demonstration, and he was doing all, yeah. So, I mean, so to me, they made it, they put a very, very, very reasonable explanation that this is how the injuries could have come to his arm. But at the end of the day, nobody really knows, whether that was from the car and there was no scavenger. It was not from the car. There was a scavenger. Did the scavenger hit his arm, within 30 minutes after he was laying on the ground dead? So that whole entire, maneuver was, in my opinion, with Hank Brennan he connected the dots in a way where there was only one explanation, and that's her hitting him with the car. And he tied in the injuries on the arm. He tied in the fact that he was by the flagpole. And there was no other explanation other than that. And it was such a reasonable explanation beyond a reasonable doubt to me. And I look at the whole thing as one continuous connected tissue.
Right. Okay. So then, just to be clear, so then Dr. Mae Russell saying that it's dog bites and no medical doctor contradicting her, but you do have Welcher, that to you, again, did not raise it to beyond a reasonable doubt.
Correct,
Right. Okay. Let's talk about the clothing for a minute, because I know you keep coming back to that. But so there's taillight found, you said, around his body, and there's also taillight found in his clothing. So let's take the body first. So we have the ARCA experts who both testified, under science principles, physics, when the car is moving at a certain speed, the taillight is going to also move at the same speed. So the taillight's not just going to stop where there's impact. The taillight's going to continue to move with force, with the 24 miles per hour. At some point, it's going to stop, but it's going to continue moving. Now, again, according to the theory that the collision occurred at the flagpole, that means that those shards of taillight are continuing to move down the yard at 24 miles per hour until eventually they rest, which would mean also, how did those pieces of taillight get to the flagpole? They couldn't have done a right turn, and somehow end up at the flagpole. They're still moving.
Any shards that would have exploded upon impact would have stayed where they were. And I believe that their expert proved the prosecution's case that some shards would have moved back. The ones that were hanging would have stuck with the car. The ones who were slightly hanging would have stayed with the car and then fallen off on the street. There was a snowplow later that day, that night before the police got there. So, the shards of glass would have been moved around, but the ones that were in his body, they did not move back and then come into his clothing. They stayed with his clothing. So, and I have opinions on the ARCA experts, but I'll let you continue.
Yeah, we'll get to the ARCA experts. Yeah. But I'm just saying, in terms of the physics, I think everybody would agree with this, and I think Welcher also. I don't think Welcher said that the tail light would stop right there. I don't believe that was his testimony. So in terms of the impact causing those tail light pieces to make an immediate, left turn to the flagpole, to me, it doesn't make sense within the world of physics. Now, if there's a snowplow that comes and blows them to the side, okay, that's more reasonable to me, as opposed to the impact causing it. And in terms of the glass that's found in the clothing, I will just tell you this, that that clothing was sitting in Canton PD before being sent to the evidence lab for weeks. It wasn't bagged and sent right away. It was sitting out in the open, drying off, where where there's no there's no real clear chain of custody, and people are coming in and out, or they could have access to it. And even if it wasn't intentional, but you got all these pieces of tail light that you're moving around, and you also got the clothing that you're moving around. Is it so unreasonable that somehow some pieces of tail light got into the clothing without anyone conspiring to do it?
Yes, that is unreasonable, 100%. I've learned that us as a species, we are not intelligent enough to keep a secret among dozens of, even between two people, that's explosive and conspire in this way. Are conspiracies real? Yes. Do police officers cover stuff up? Absolutely. But that's been proven time over time again. Is it possible that the entire, as I called it, pole vault maneuver of a conspiracy, to where you continue that momentum throughout the whole entire pole vault maneuver. Was that possible? Not at all. It's like pole vaulting over the
Right.
Twin Towers. It just wasn't going to happen.
I
think
I'm
that
not,
would have been unreasonable. Yeah.
yeah, I'm not
Sorry.
talking about intentionally. I'm talking about even unintentionally. You've got the clothing
Unintentionally?
sitting. Yeah, you got the clothing sitting out in the open in the evidence locker or whatever, that room. They're out there to dry for weeks and weeks and weeks, and then while all they're gathering this evidence of the tail light, and they're coming into the room and out of the room, and who knows how they're bagging it together.
Yeah.
Is it unreasonable that unintentionally or even mistakenly, that somehow a piece of tail light that they're collecting in the same evidence room would somehow fall into and we're talking about a minute microscopic piece.
Yeah.
Is that unreasonable?
I think it's unreasonable because they were in separate bags. The clothing was in a bag. The taillights were in a bag and their own box. They were not in the same thing. There was no cross contamination. The people handling it would have had the people handling it, if I recall correctly, the people who were in the chain of custody, forgive me if I'm wrong in this, they did not testify in either trial, right? And they were, functioneers in the forensics of Canton PD. Forgive me if I'm wrong on that, but that's my recollection sitting here now. So it would have been unreasonable to think that.
Yeah. I mean, one of the problems is that there was a real big problem with chain of custody. It wasn't so clear chain of custody. And also, again, they were not bagged. The clothing was not bagged. It was laid out in the evidence room to dry off for weeks and weeks on end while they're still gathering all these pieces of taillight. So is it, and again, we're talking about a microscopic piece. So
So chain of custody, we learned it when we were younger. Chain of custody matters the most when it comes down to rebutting conspiracy, rebutting cross contamination of blood and DNA and stuff like that. When it comes down to clothing and things that are not like we're not talking about blood or DNA or semen. We're talking about a piece of fiberglass and a piece of mesh clothing, right? Chain of custody is obviously important, no question, but it's less. I'm not gonna say it's less important with non-DNA, non-semen, non-blood, but it's not like a piece of DNA with an improper chain of custody is useless. Same thing with blood, same thing with semen. Clothing and glass are not the same. And so you would have to make the leap that the glass got into the clothing, and what like a 1 in a million chance of that happening in that situation. To me, I didn't see that.
Okay. And again, I understand the pause that people may have that you got this clothing sitting out in a room, just not bagged. People have access to it coming in and out, and they're collecting all these pieces of taillight. I can see how a microscopic piece may have been dropped in there. And then the other part of it is that just that part, let's just talk, you're talking about a 40-person conspiracy. Let's just talk about that one part of somehow getting some taillight in his clothing. That would have taken one person, maybe we'll call him Proctor, to do it, and nobody would have to know the better.
If I recall correctly, Proctor was not in the same room as any of that evidence. Forgive me. I knew this down to a science during the trial because we debated it live. I don't recall whether Proctor was privy to the physical evidence by the time, like when the clothing and the glass and all of that were collected and stored. I don't believe he was.
Well, I mean, he signed on a lot of those evidence bags of pieces of taillight, and so he had to have had access. And you know how when you need access to your police officer and your buddies with somebody, just let me in there, let me get some access.
Yeah.
And and again, you're dealing with Proctor, who has been proven in this case to have been incredibly lacking integrity, to put it nicely, and he was. He was what's it called? He was fired from the job because of his bias and prejudice, in this investigation itself. So, would you put it past somebody like that who is that terrible to, on his own, without involving a 40-person conspiracy, to somehow mix up some of the taillight with the clothing?
I have some thoughts on that, and this is something I'm very, I have strong feelings on this. I said publicly that Michael Proctor is an imbecile. I believe that he did a big disservice to the people that he was serving. You're not going to see me defend Michael Proctor. With that being said, I completely put it beyond him to fabricate evidence because he was worried about numero uno, which is himself. I don't see how he could he have done this on another case? Maybe. I don't believe he did that in this case. I don't believe he was in the same room or even had the ability. I know that he was at that garage, right? And the only time he even had the ability to do this was when he was in that garage, when there was a camera, and then he was on the other side of the camera. He would have had to take shards off there, collect them, go back, find the clothing, and put it in the clothing. That was the only way that Proctor could have done it. I just don't believe he had the intellect, the motive to get it done. Yes, he was biased. He called her a whack job. You and I have daughters. The word whack job is, to me, it's anathema. It's like how are you going to talk about it? Because at that point she's just a female and he's just talking about her that way. And so I believe he should have been fired. But I absolutely put it beyond a guy that dumb to do something that, so like it's so risky and for what at the time he probably thought the case would have been proven beyond a reasonable doubt. Have police done this before? Of course. You and I, we've been in cases where all of a sudden we expose something that an investigator has done or a police officer has done or a responding officer has done, and then the case is dismissed right away. We've been involved in those cases. So I completely put it beyond him in this specific case based on the way the chain of custody happened with her vehicle, her Lexus.
Yeah, I mean, but it wasn't just, in the Sallyport, which, I think that you're talking about that Sallyport video where he was behind the Lexus. And by the way, there is some dispute about 45 minutes missing from the Sallyport. We all remember Kelly Dever, her testimony of her false memory of things going on in the Sallyport. So, this specific instance, when you're saying, yeah, he could have done it in another case, which you've said with a straight face.
Yeah, but I have no idea. I don't know.
No idea, but you wouldn't put it past him, right? So if you're saying that so now you are putting it past, what are you saying about that?
No, it's not that.
A second ago.
No. It's because neither one of us know Michael Proctor, but I feel like, by the way, am I confident I'm right whether he would have done it or not? No, because I don't know the guy, but from my limited experience and observance of the guy, the personality types of people. Like, there are some people who are very slick, investigators, police officers, responding officers. They're very, very, very slick, and they are corrupt to the core, right? And then there are some who look corrupt, but they're not corrupt at all. You never know. Now, would I put it past him in another case? Maybe, but then again, I don't know. All I know is that my observing his maneuvers in this case and his access in this case, I do put it past him in this case just because of his access and because what he would have had to be protecting people that he had no reason to protect. And I'm sure you're going to get into the relationship between the Alberts and Proctor. If not, I'll just say, there was not enough of a relationship for him to go out there and put his neck on the line to cover up somebody that he did not believe had anything to do with the murder. And that the forensics shown later on that there's no way John O'Keefe, whatever you believe on the flagpole, that he made it into that Proctor home, let alone die in the Proctor home, in the Albert home, let alone die with 11 people at a birthday party, and then they all covered it up. So I just don't believe Michael Proctor would have said, this is the case where I'm going to go to jail for 25 years for covering up evidence and being disgraced, which clearly he didn't want to happen to him, but it ended up happening to him.
Right. So he's dishonorably discharged. We all saw his conduct on this case. And that's why people I would disagree. I think he did have access in this case. His name is on a lot of evidence bags, and it's not just the area in the Sallyport. He was the lead investigator of this case. So when you're asking me, you're asking people, say, hey, there's some microscopic. One of two what?
One of two lead investigators in that case.
Well, I think they eventually agreed that he's the lead investigator, even though in the second trial they tried to stay away from it. But eventually they got it out from a few different people. So. You have Buchanan, whatever, but he was really the lead investigator. Yeah. And so that would mean that he has access, I think, to everything at any time. And, again, if you're just talking about one person who we can't trust at all to do one little thing of deposit some taillight in some clothing and nobody else involved, you're not talking about a 40-person conspiracy. So I think that's where people will say, okay, that's not proof beyond a reasonable doubt just by the fact that you have a microscopic piece of taillight in his clothing. Let's move on to ARCA, because I know, this is the big selling point for me. This really did it for me. And so here's the first question. Dr. Wolf testified, and I think this is really uncontradicted, that the taillight was not just shattered from the outside, but the diffuser inside of the taillight was broken. It was shattered. It was, it was shattered from Karen Reed's real Lexus. And in all the testing that they did with those dummy arms, as you know, the diffuser wasn't damaged the same way. There's maybe only, I think in the most severe case, there was very slight damage to the diffuser, nothing like the damage to the diffuser in Karen Reed's case. So how did that diffuser break?
So their conclusion obviously is that somebody used a hammer, somebody was trying to do the conspiracy, they broke it, they went too far in breaking it and causing it. That whole thing was, in my opinion, thoroughly debunked. I'll tell you many reasons why I did not believe it. So the ARCA experts did what they were supposed to do. They were the expert witness for the defense. They were paid by the defense. There's nothing wrong with that. We hire experts. We pay experts. We never tell them what to do, but an expert is gonna say, what they believe. But they were the defense expert. The experts on the other side said a story that helped the prosecution. I'm not saying I believe them wholeheartedly, but when in the second trial of the ARCA expert, I lost the taste for them because they refused to, that whole line of questioning and cross-examination where Hank Brennan asked them, did you delete your messages with Alan Jackson? He refused to, that was Wolf, you said?
Dr. Wolf, yeah, Rentschler was fine, but yeah, Wolf.
Okay. Yeah. He refused to agree to say, to acknowledge that he deleted his messages. He had the snide response. I have no reason to keep messages that are a year old. But that's not what I asked you. I asked you, did you delete them? Why would I keep messages a year old? Why would I keep them in my phone? I know, but I'm asking you, did you delete the messages? Sir, I told you, so it was that. So the reason I say that is when you see a witness refuse to concede a basic point, they have an agenda. He refused to acknowledge, to concede very basic points. Later on, there was another expert. Hey, good morning. It's not good morning. It's afternoon. Like, they have an agenda. So to me, as a guy who looks at the expert, everything they say after that, I kind of tune out. So you're asking a very intelligent question, which is, what about this thing that he said? Yeah, but if any one expert on any one side is believed wholeheartedly, then the case either is a conviction or it's an acquittal. That's it. There's no question, right? It's just in the totality, that the diffuser, like, what do we really know? There was a blizzard out there. John O'Keefe was standing on shaky ground. His feet he was standing in snow and ice. You're not going to be able to recreate that with a test dummy. The test dummy was in a dry environment or in the garage or something like that. You're not going to really know. You could take a hammer and smash 10 glasses in the same way, the same force. They're not going to all shatter the same way. So to me, that was not compelling either way for either side.
Right. Okay. So, and to me, I think it more comes down to the, this is a physics equation. It's not something that you can mess around with, so like and in terms of what the prosecution, Hank Brennan, they didn't do any of these tests. So they can't say, well, when you test it under these conditions, when there's snow or ice or whatever other conditions that you were talking about, they can't say, well, we did some testing and it shows that the diffuser could be broken if it's smashed into the arm. So here's where, Wolf's saying that the damage to the vehicle is not consistent. Yeah, so it's not consistent. And therefore that can say, okay, well, that points to the conclusion that the car didn't hit him. And if it would have hit him at these speeds, then it wouldn't have caused the severe damage that we saw in Karen Reed's Lexus. Another point that he made for Dr. Wolf, and also, by the way, I think also what was compelling for me is that these were not the typical experts that you and I hire in every case. These were experts that were hired, not by Alan Jackson. This is hired by the DOJ. As far as we know, they're
That's one that I took great issue with.
So tell me.
Yeah, so I took great issue with that. So I believe Alan Jackson is a fantastic lawyer. If a loved one of mine needed a defense attorney, I'd want to hire Alan. He's awesome. I think he crossed the line ethically on one kid. Maybe I would have done it too. I don't know. I've never been in a
You wouldn't have done
situation
it.
where
I'm sure you.
yeah. I've never been in a high profile case where my life's client's on the line and I fully believe she's innocent, and I wouldn't have made the mistake he made. What they did was they presented to the court that these are independent, unpaid experts, which was a lie. It was dishonest. And I forget the words that Judge Beverly Canoni said. Something like I forget, sanctioned them
Yeah.
with
Well,
severe.
she did. Right. She did say, well, she said that she had grave concerns, but she had grave concerns about it because there was
Worse. She had worse. She said she had great concern, and she entered an order,
right.
Admonition, a severe admonition, which is it's a signal to their state bar, Yannetti in Massachusetts, Alan Jackson, California. It's a signal to them that you need to bring them up on ethics charges, and she
No problem. Okay, so let's go back. So we're talking about you're talking about how Judge Canoni sanctioned essentially Alan Jackson. By the way, one of the sanctions was that they had to turn over their communications with the expert, which I'm sure you would never want.
Yeah,
well,
they deleted. Yeah,
so
they deleted. So they were not that whole thing of them being hired by the DOJ. They were hired guns, which is nothing wrong with that. They were hired guns for Alan Jackson, and Alan Jackson was parading them as though they're this independent. To me that shocked the conscience. As a lawyer, it just shocked the conscience, and they were not independent, and that's okay for them not to be independent. But dude, don't say they are, and they're definitely not.
Well,
and that guy, and that guy, he just creeped me out. The second guy, the wolf guy, he just creeped me out when he refused to admit that he deleted the message. It's okay to say I deleted the messages, but it's not okay to say did not even answer the question.
Right. So, but here's my pushback. My pushback on that is that yes, they did hire them for the case, but when they conducted their initial accident reconstruction, they were not hired by the defense. They did that for the DOJ, and now we are going to now pay you to testify about your testing that was done, which generally speaking doesn't happen. Usually we hire somebody, then they start the review of the whatever they need to review and the testing, and that's what Welcher did. But these guys from ARCA, they did their initial testing before having any contact with Alan Jackson.
Not at all, not at all helpful to either side. Not at all this wild card that the defense was saying that they are, and here's why. The federal government was involved in this case, in this investigation. They had to have their own expert to do a forensic analysis for them anyway. You as a defense attorney or a plaintiff attorney or any kind of attorney, right? If there's an independent report, you look at it. If you like what it says, you hire the person. When you bring that person under your tent, what's the story that we use? It's better to have them in the tent pissing out than out the tent pissing in, right? So they brought them into the tent to piss out of the tent. Okay. That's okay, but they were not an independent. By the time when they took the stand to testify in that case, they were an advocate, period. Plain and simple. They were an advocate for Karen Reed, which is fine, but that's exactly what they were. They were not some independent, holier than thou body that was there to help us with their expert, because there was an expert on the other side who said exactly what the state wanted him to say. They didn't take him aside and say, do what we want you to do, but that's what he did. True or false? That person could have easily been hired by the DOJ, right? And then if he said the same thing that he said later on for the prosecution would have hired him, and then the defense would have hired their own expert and said, this expert is an idiot. And one last thing, and I brought up the Stairway case because I'm studying that case right now, because I get fascinated with one big case a year and I study it. And I'm studying that case, and the expert in that case, I think his last name was also Deaver, if I recall. He ended up being dozens of people convicted and went to life in prison over him just lying about just doing experiments that proved what the state wanted, and they were bogus science, right? I'm not saying the ARCA experts are the same way as him. What I'm saying is my respect for any expert on any side to take what they say as gospel, as just the God's honest truth. It just doesn't exist, because in reality, it really is not true that any expert for either one of these sides can be taken, their words being taken as gospel, including the ARCA experts. Again, two of the defense's experts, they refused to concede basic points like the time of the day, good morning, what the weather.
Well, by the way, I just want to point out, Welcher actually did that to Brendan also.
I didn't know.
Because Brennan
All right,
did say one time, "Good afternoon," and he said it's morning.
It's
okay.
cringeworthy, isn't it? It's cringeworthy on both sides. It's cringe. By the way, when I get my experts ready, I'm like, dude, tell the truth and not just be a normal person. You're a normal. You're going up there. You're talking to another person in front of the jury. If somebody asks you something, just concede basic points. If there's something I forgot to tell you, and they ask you, and it's going to embarrass me or embarrass my, just say it. Just come out there. Don't get there like you're not. Don't worry, man. I'm not giving you an extra commission if we win the case. Just be a genuine person and just talk genuinely, right? So yeah.
But Mike, you'll agree that when they did the acts and reconstruction, they were not hired by the defense.
Yes, I do agree.
Right. So in that way, in that element, they were objective.
Before they were hired by the defense, yeah, they were.
When they did their act and reconstruction, saying that it's not consistent, they were independent. And then, yes, they were hired by the defense. And at that point, you can say they're an advocate. But when they did the testing, they had no idea who the defense was.
Here's my response. This is what I say in every case. Their opinion was not motivated by pecuniary gain, right? Their opinion before they were hired for the defense was not motivated by pecuniary gain. That does not mean that what they said to either side could be taken as gospel. I don't think that's what you're saying anyway, but yes, their opinion was not motivated by either the defense or the prosecution. Yes. Before they were hired by the defense.
Right.
Yeah.
That's right. So that part the defense had over the prosecution. That's all I'm saying. And
sure. Yeah.
So now we're going to talk about another thing. Another thing from the testing. And again, I don't know if you want to discount the testing at all because whatever, but another part of the testing that Dr. Wolf showed was that the sweatshirt that they were testing all of these impacts on never got holes in them. And John O'Keefe's sweatshirt had a bunch of holes in it, 9 holes or something.
Mm-hmm.
All the testing showed that no matter what impact you hit that arm at, the taillight is not going to cause holes in the sweatshirt. So what's your response?
Remind me one thing that I'm forgetting. Didn't they redo a more robust part of the experiment after they were hired by the defense? This is something yes. Okay.
Right. So I'll tell you what they did. Just to be very clear. What they did was that the first time they were hired by the DOJ and they did their action reconstruction, they didn't do the dummy tests.
Yeah.
They did the dummy tests in response to Welcher showing on his slides that arm at a right angle.
I totally discarded. Just like I discarded the expert for the prosecution, which you haven't asked me, and I'll tell you. I discard what he said. I don't think that what he said can be taken as gospel. But I also discard the ARCA witnesses as well. So any testing they did, one of them is right. It might be the ARCA experts. I don't think it is, but it could be the ARCA experts or the prosecution's expert. But at the end of the day, it's just a battle of the experts at that point in terms of, can anybody really look you in the face and look me in the face and say, I know exactly how this would happen out of every 100 times that this exact impact is going to happen. The same result will happen 100.
No, no one can say that. But what they
nobody
could
can say,
nobody can say that. But what they could say is that it's consistent, meaning it doesn't have to create the same amount of holes and geometry of the holes and amount of holes and whatever. But are there holes? Are there any holes that were created by any of the experiments and all their experiments at all their speeds? There was not one single hole that they were able to put into the sweatshirt. So to me is compelling.
No. When they say this is consistent, which is all an expert could ever say, right? A blood pattern expert, a trajectory expert, all these experts, all they'll say is this is consistent with this, right? And I've seen experts testify. Again, I hate to bring this up, but the stairway case, they brought in an expert who actually wrote the book on blood pattern analysis. He's the Japanese doctor. He actually wrote the book. Actually, he's the most well-known speaker on blood pattern analysis. And when he testified on behalf of his client, he was hired by the defense. He said, this is not consistent with a murder. And the prosecution asked him, can you rule out 100% certainty? Can you rule out that this was a murder? He's like, well, nobody can rule out anything. He was paid by the defense to get the guy acquitted, and the guy ended up getting convicted. because the expert refused to say, I cannot rule it out. Later on, it was proven that he did not murder his wife, right? But the expert for the state of North Carolina said, I can absolutely rule out this being an accident. I can rule it out conclusively. He ended up getting debunked and put a bunch of people in jail. The reason I say that is because the ARCA witnesses were more like him than they were like the expert who said, I cannot rule it out. They would not concede basic points. So by the way, if you're saying that the ARCA experts did a better analysis, you might be right. By the way, you might be right. But they would not say, if you had them on this podcast, can you rule out any chance she would have hit him? Yeah, we'll rule it out, guaranteed. To me, they did not say that to the DOJ. They did not tell the DOJ we completely conclusively rule out a murder. They did not say that. They said it's not consistent. That morphed into I'm going to prove that she did not hit John O'Keefe. And to me, there was too much of that on both sides.
Right. Okay. Yeah. I mean, but you know how experts talk. I mean, like we're talking.
Yes.
You know, experts always say consistent. They'll never. And as we heard, Welcher as an engineer, you know, you won't rule anything out because anything's technically possible. You know, but it's not consistent. And then the question is, okay, well, when they did all these testing and there's not one single hole that is generated by this taillight smashing into the dummy and using all the force calculations that they did and all physics and science, whatever, does that create some reasonable doubt that maybe this actually didn't happen? You know, you don't have to prove that it didn't happen. All you have to do is say it's not consistent with this happening, and that in itself can, now I have some reasonable doubt. And that's where a lot of people fall.
I can answer that question. In two ways. There is not a single piece of evidence presented by Hank Brennan in the second case that in and of itself conclusively proves that she killed him beyond a reasonable doubt. So the question then becomes, did the defense knock down any peg to create reasonable doubt? I don't believe they knocked down any peg that creates reasonable doubt on the second charge and the third charge. I think they did it on the first charge, right?
Well, we went through that.
Yeah. So no, for me, like if I was on the jury, I'm saying, given the fact that they would have had to convince 12 people, and you know how groupthink works in those juries, right? To convince 12 people, like if you go into the jury room and there were 2 jurors who believe what I believe, which is it was proven, right? And there are 10 saying that it isn't. You and I both know they're going to overwhelm those 2 people. It's just experience. It's studied. It's known. People know that. There are jurors who to this day say, I regret voting guilty on this one person. You know, I regret. I shouldn't have done it. Now I'm living with it. I'm traumatized.
And I'm sure just to share with everybody, you know that on jury selection, this is one of the things that I always like to focus on with the jurors. I say, if you believe something to be true, are you just going to give in to the other ones because you're getting pressure to do it?
I like that.
I want that juror to stick up for me.
You know, I'm gonna use that on voir dire. I like that. I like that a lot. Actually, you always learn something new when you talk to people that are intelligent, and you're one of them. So I just learned something. I am gonna do that because it really bothers me. Groupthink bothers me in these jury pools. Look, there was a case I was talking to a buddy of mine where there's 2 holdouts. A girl became a paraplegic for the rest of her life. These 2 jurors held out on $30 million. They ended up agreeing to $3 million because the 10 of the jurors want $3 million. She's paralyzed, young girl paralyzed, hit by a garbage truck. The guy was distracted. Anyway, point is that's neither here nor
really?
there.
Sheesh.
Yeah. Paralyzed for the rest of her life, paraplegic. Yeah. Anyway,
I mean, $3 million is not enough for the rest of your life. You know, 30 million is you can start talking, but
30 million just for her family to take care of her and having a full-time. Anyway, but I'm sorry. My apologies. I went off on a tangent. But there's not a single piece of evidence that the prosecution did that in and of itself convicts her. But your question is, do I believe that if the ARCA expert said X, Y, Z, that creates reasonable doubt? Absolutely not. Absolutely not. Because I look at it all in conjunction, all the evidence in conjunction. There is not a single. There's nobody. The defense didn't even try to explain how he could have died. It's not their job. They didn't have to do it. But the prosecution did enough to prove their case in chief beyond a reasonable doubt because they closed what Hank Brennan did was he closed the world. He made the world small into that one incident, into the incident that started with Karen Reed dropping him off. He shrunk the window of events. I loved it. In the first case, they focused so much on the conspiracy. But in the second case, Hank Brennan shrunk the universe. And I believe that it was proven beyond a reasonable doubt.
Yeah.
But if these jurors went into that jury room hell bent on, and I believe these jurors, if you want to ask me later on, I think the jurors went into that jury room hell bent on acquitting her, and they believed what they heard from the conspiracy merchant. I wish they would have listened to podcasts like yours. They would have actually thought about the case intelligently. Maybe they still would have acquitted her, but then again, they would have done it intelligently. There was just so much imbecility on that jury based on their interviews they did later on.
All right. So let me move on a little bit more to, okay. So we spoke about the diffuser. We spoke about the punctures in the sweatshirt or the lack thereof on the testing that, which perhaps can create some reasonable doubt. Let's also talk about something that Dr. Rentschler brought up, and that is that there was 9 punctures on the sweatshirt, but 36 abrasions that he counted. And how are you going to get 36 abrasions from only 9 punctures? That was, that's compelling. And people can start thinking, okay, maybe it didn't happen because it just doesn't line up.
No, I mean, listen, if you were to take an experiment, if you take a butter knife and you scratch your arm over your shirt and you don't puncture the shirt and you look underneath, you're going to have a scrape on your arm. That one was not compelling to me either way. Because it, just logically speaking, you don't need to puncture a shirt in order to have an incision. You don't need that.
Okay. And the other part is that Rentschler, I think also one of the most compelling parts of his testimony, to me at least, was the fact that we're talking about superficial abrasions. We're not even talking about lacerations on the arm. Mm-hmm. And remember that the contact has to be so strong that it breaks the diffuser, the internal diffuser of the Lexus, not just the outer lens of the tail light, but also the
that's fair. Yeah, that's
component. Fair. It has to break it and only cause superficial abrasions, no fractures, not even a hairline fracture, no dislocations of the arm. So at the same time, you're asking the jury to believe that this was a serious enough impact to break the diffuser, but yet only cause on the body superficial abrasions, not even a laceration and not fractures.
Two responses to that. First and foremost, then the only other explanation is somebody intentionally broke it. Number one. Well, no, you're probably going to tell me that maybe she backed into his car at his house, but you definitely. But let me just answer your question. We'll get to that one. Either somebody then intentionally used the hammer. Number one. Number two, that cuts against the whole dog bite theory of Dr. Marie Russell. Like, okay, though, if it's just superficial abrasions, dogs don't cause superficial abrasions on one side of the arm. They actually they get deep into your arm on both sides. So that cuts against that as well.
Yeah, but Mike, nobody testified to that.
Oh, if your thing is, yeah,
about
okay,
trial. If he would have had if he would have had an MD,
that was a mistake by Hank Brennan. Yeah, that was a mistake by Hank Brennan.
Yeah, so then we're only looking at Marie Russell said it's a dog attack.
Yeah.
Posada said it's a dog attack. There's no Crosby. You've got the ARCO expert saying the damage to the vehicle is too great, and the injuries are not fractures and they're only superficial abrasions. It just doesn't work. Yeah, and that's where people start having reasonable doubt. And I'll tell you that I've spoken about this case, and I've told my channel also a bunch of times, I don't think the conspiracy is proven at all. Good. I think there's a lot of questionable activity that we can talk about, but
yes,
I don't think that the conspiracy is proven. But when people say, okay, well, what's your alternative theory? What do you think happened to John O'Keefe? My answer is, I don't know. I don't think I think, Mike, here's my problem. I think that because we had such a sloppy investigation, because we had people like Michael Proctor running the investigation, a proper investigation was never done. And therefore, we're unfortunately not going to have the answers to these questions.
Yeah.
That's my fair position.
Okay. So here's my
I guess I fall into your category 2.
Category 2. You're in category 2. I love people in you're a man of my own heart, because category 2 is just as reasonable as category 1, right? They're the same. There's no difference. Category 1's not better than category 2. We're equal. It's just category 3 really drove the analysis, but they also polluted the jury. They polluted the jury. Jen McCabe getting followed to her daughter's softball games and called murderer and stuff. To me, that is beyond disgusting. It was so ridiculous. But people who believe that Karen Reed, the case against her, was not proven, tip the hat to them. They might listen. They might be. That's a reasonable conclusion to make. I don't make that conclusion, but it's a reasonable conclusion to make. I just don't think that that drove the day. I don't think that carried the day. I think what carried the day is these conspiracy merchants, again, because the interviews that some of the jurors did after the fact, to me, was beyond the pale imbecilic.
Well, you know that, jurors hang their hats on certain pieces of evidence that we sometimes we're thinking, oh, this is going to win the case for us. And then the jury tells us, oh, no, it was something else. And you're like, what? Why in the world would you think about that? We had such better evidence. But I mean, that's how juries are. We can debate this all day long, but they're not lawyers in there, and they're not.
It's a casino.
Yeah. I mean, it totally is. We both know that. So, what the jurors said afterwards or whatever, okay, whatever they hung their head on. But I'm just talking about, in terms of if I was sitting as a juror, that's how I always look in these cases. Obviously I have the experience and knowledge, but, I completely agree with you that none of these witnesses, Jennifer McCabe and all these people, shouldn't be hounded and shouldn't be, called murderers and all these things and harassed at their kids' games. I'm obviously not a proponent of that. I'm just trying to look at the evidence critically and come up with some sort of conclusion here, which is why I've maintained that all these things together. And we're not even talking about, the butt dials and the butt answers. And we're not talking about, the fact that they rehomed their dog and sold their house. And, nobody saw the body when they left the house. These are questions also that people will say, hey, you want to talk about common sense on this case? How does 7 people leave a house when a 6'1" man is sitting on there and nobody see him? How does
that one was easy because it was far, it was dark, and it was like 1 o'clock in the morning, 2 o'clock. That one makes total sense. But like I walk outside of my house now. I do it because of the case, but there are tons of things that could be on my lawn. I just don't see. I don't live in a big house. I live in a quarter of an acre, type house. There's no way at night that you would even think to look at a part of the lawn that doesn't have a driveway on it, doesn't have anything of no mailbox. That one makes sense. That one made total sense to me.
Okay,
because you'd have to then believe the conspiracy. You would naturally have to believe that it was a conspiracy. You'd have to.
I understand that. I'm just saying the people that are screaming conspiracy on this case, and I'm not one of them, but the people that are, and they're pointing to these type of things where all those people leave the house, all the butt dials and butt answers, phone calls that they claim never happened, and really, the data shows that it does happen. You've got these steps and these incline and decline that Ian Whiffen was talking about, which was
on John O'Keefe,
right, and which was according to him, you trick Apple technology. You're talking about technology that Apple spends millions of dollars on, and you can just trick it by holding your phone in the car. These are things that are hard for people to just completely digest, which is why I think they jump to the conclusion of conspiracy or something crazy instead of there may just be things that we don't have answers to and we can't reasonably explain, and then and then it's just, is that reasonable doubt or not? So that's kind of where I fall. Can I ask you, I know we're getting late here and I know you've given me so much of your time and I appreciate it. Let me ask you one question, because this really bothered me. This really, really bothered me. And people have always asked me on my channel, do you think Judge Cannoni was fair? And I've always maintained that I don't love the way that she runs the courtroom. I don't love what she did with objections. The fact that you can't state the basis for your objections. There's a number of things that I had issues with, but I always told people I haven't seen blatant bias by her. However,
go ahead.
However, there's 1 or 2 things I cannot wrap my head around. One of them is when she went and made Dr. Marie Russell go through a 2-day Daubert hearing before she was allowed to testify about the dog bites, or, saying that these were dog bites. And then when it came to the prosecution's expert, when the defense tried to challenge them on Daubert grounds, there was no Daubert hearing. There was no, question. And she just kind of Crosby, he's not a medical doctor. He's not nothing, but he's going to be able to testify that these are not dog bites. Did you think about that? And do you have any insight or explanation?
I did. Yeah, I did. That's a very intelligent question, man. This is the type of the debate that was missing in this case. Unbelievable. All right, so this is really good. Again, I'm not used to this, and in this case, okay.
I'll take that as a compliment.
No, this is the utmost compliment, utmost deference and respect to your channel and what you're doing, because this is the type of debate people need to see on cases of this magnitude. I absolutely believe she ran a fair courtroom. I absolutely believe that she was deferential to both sides equally. I absolutely detest the whole thing of you can't state the basis of your. How dumb is that? Just us as lawyers, just stupid, right? But I don't think she did that to hurt either side. And I do believe she should have sat Dr. Russell through a Dauber hearing. I think it was justified. Earlier in this podcast, I said I don't believe she's an expert. Right? I was proven wrong, but I still don't believe she's an expert because the whole question is: did you die from the dog bites? Are these dog bites? And there are actual experts on dog bites. And again, just basic stuff like there's no dog incisor wounds on the bottom part of the arm. With that being said, your question is, do you think she should have put her through a Dauber? Absolutely, because she came into the case after the case started. She called the defense and said, I want to be an expert. Of course, you as a judge have to know what's your agenda. Why did you all of a sudden see the case on TV, reach out to the defense and say, I want to testify? You clearly want to help them out. You did not call them because you think that you have this fountain of knowledge that all of us want to know. You want to be on TV and you want to help one side. I think she should have done that if she came to the prosecution. I don't think it was a defense thing. I think the judge did the right thing. And imagine if she didn't do it, she would have been screwed. With that being said, this is a state judge. These are politicians. They run for political office. You and I both know that. They're not federal judges. Federal judges are Article 3 judges. They're appointed for life. They can't.
I actually think the Massachusetts state judges are appointed also. I think. I'm not 100% sure, but I think they're appointed.
No, some of them are appointed, but they're still political, right? Some of them are appointed. Okay. Not all of them are on a ballot, but they run for re-election. They're still political. They're not like federal judges, right? They're still state court judges. And so on top of that, she grew up in that community. She lived in that community. She was in a pressure cooker. She's more of a politician than a judge by the very nature of her affliction, right? Which is what she had to do. And she landed this case. And she knew that for the rest of her life, she would be judged on by the community. Once the cameras are gone, once the public limelight is gone, she still has to go to the grocery store and hear epithets and happy. Maybe people will put a piece of dirt in her carryout food if they see Beverly Cannoni on her takeout. Like she has to think of stuff like that. And so that factors into the mind of a judge in that situation. I know judges who are judges on high profile cases, and they've all said the same thing to me, which is I got to be careful. I got to be a judge, but I got to be very careful. Everyone's looking at me. I can't be lazy. I gotta shave my beard. I gotta show up to work. I gotta do things. People are watching me, and they'll excoriate me if I make a mistake. So, I think she did play it right. I think she was on her best behavior because she knew everybody would look at her. And by the way, I think we could all agree that the overwhelming majority of people in her constituents believe Karen Reed was innocent. So she had to acclimate her behavior to be at least 50-50 with Karen Reed's side.
Okay, so just 2 points. Number one is that I know in the first trial she came in the middle, but the second trial, before the second trial, when they already had her listed and there's no surprise there, the second trial, she made her go through the Daubert hearing before this trial. So, in terms of that argument that she's coming in the middle because she got
I forgot that. Yeah, I forgot that.
That's and also, again, it brings me to the second point, which is, if so, then why wasn't the prosecution's expert, who wasn't an MD, by the way, who's going to opine about causation, why did you not make him go through a Daubert hearing?
Remind me the expert for the prosecution in a second, in case you're referring to Crosby, and he was going to testify to the causation of the death?
No, when I'm talking about the causation of the injuries to his arm, that I believe he was going to say that they're not dog bites. So,
I don't believe a doctor. I listen, and this one, the judge agrees with my position. I don't believe that a doctor is necessary, can even be an expert on canine bite marks. I just don't believe a doctor can do that, because a doctor, just think about it, you're a doctor. People come in with the flu, people come in with COVID, the next person comes in with a broken knee, the next person comes in with diabetes. Like, you're not an expert on dog. Now you're going to say, well, she's seen thousands of them. Okay, but that's not her expertise are to treat infection, to treat the infections related to dogs, to rabies. An actual expert on dog bites are, I forget the name of it. There's like two different types of experts where they are an expert on dog bite patterns. And that's the question: is this a dog bite or not? Not this is definitely a dog bite. What harm did it cause us? Whether or not this is a dog bite. Dr. Russell knows more than I do, way more than I do about that. Way more than I do. Clearly, you've showed a clip that shows that I don't know anything about these dog bites. I have no idea. But she's not somebody who can overcome becoming an expert without a Daubert hearing. And it was an issue.
And you think that Crosby is?
I do. I believe. I'm forgetting the type of expert. There's two types of expert.
He was like a dog behavior expert or something. Like he wasn't.
Okay. Was it a dog behavior or a dog bite pattern expert? He's something more related to an expertise that would render you an expert on whether or not those marks were from a dog bite.
Right. So okay. So bottom line is that you're saying that you think that was the right ruling, meaning make
I do believe.
Make Dr. Russell go through the Daubert hearing, and Crosby not have to go through the Daubert hearing.
Yes.
And again, for me that's difficult because in my world, again, plaintiff, personal injury is you get a doctor to talk about injuries, and that's it. Nobody else. But okay. So look, Mike. I'm sure we could go on for another 2 hours, but you've given me already 2 hours, and I very much appreciate. I know you're a busy guy. You're running like multiple law firms, and you're on court TV all the time. And appreciate having an actual real debate with another lawyer. I've been asking, actually, I don't know if you've been getting my messages, but I've been asking to have one of these type of debates with another lawyer so we can talk lawyer to lawyer about the evidence, about the facts, and how we come to different conclusions about it. I think what you're saying ultimately is that the totality of the evidence that Hank Brennan put on, proved the case, even second-degree murder, beyond a reasonable doubt. Mm-hmm. To me, the totality of all the defenses, La Posada, Dr. Marie Russell, the ARCA experts, the totality of all that put doubt in my mind, and therefore I say that the case was not proven beyond a reasonable doubt, and that's kind of where we have our disagreement.
That's fair. And by the way, that's a very reasonable disagreement. By the way, there's only two universes in this case. There's a universe where she did it, and there's a universe where she didn't. There's a universe where she did it, and she's lying about it, and there's a universe where she didn't do it, and she's telling the truth. We have no idea which universe we live in. Maybe one day we'll find out.
Maybe. Well, thank you very much, Michael, for coming on again, and all the best again. Thank you very much. Thanks so much. We'll be in touch.
Thank you.
All right, everybody. Well, that is it. That is the debate between myself and Big Case Mike. Hope you all enjoyed it and heard our different perspectives about it. Maybe you agree with one of us. Maybe one of us were able to sway you to our side or the other side. But ultimately, I'm very happy that I was able to sit down with Mike and talk out all the issues in this case. So that's going to be it for now. If you haven't yet, by this time, please subscribe, please like, and we will see you next time.